Hello everyone, my name is SEHAJ BRAR, a student of class 8 from DPS Khanna. Today I am here to share some information on the topic the judicial system of India. The topics we are going to discuss in this presentation are the judicial system of India, Supreme Court, High Court, district or subordinate courts, Lok Adalat, fast tracks, tribunals, role of courts, appointment of judges, and accessibility to the courts. Now let us discuss about the judicial system of India. The judiciary, also known as the judicial system or the three-tier system, is the system of courts that interpret and applies law in legal cases. The Indian judiciary is a continuation of the British legal system known as common law system. This system is a single integrated system. The Constitution of India divides the Indian judiciary into superior judiciary, the Supreme Court and the High Court, and the subordinate judiciary, the lower court under the control of the High Court. Now let us study about the Supreme Court of India. The Supreme Court is the highest judicial court under the Constitution of India, the highest constitutional court with the power of judicial review. The Supreme Court of India came into being on 28 January 1950 and substituted the Judicial Committee of the Privy Council and Federal Court of India, which were the apex legal system under the colonial rule in India. Consisting of the Chief Justice and a maximum of 34 judges, it has an extensive power in the form of original, appellate, and advisory jurisdiction. It is regarded as the most powerful public institution of India. High Courts. The High Court of India are the principal civil courts of original jurisdiction in each state and union territory. There are 24 High Courts in the country. The High Court may also have an original jurisdiction in certain cases if permitted under the federal law system. All the High Courts come under the jurisdiction of the Supreme Court. However, a High Court exercises its original civil and criminal jurisdiction only if the subordinate courts are not authorized by the law to try such matters for lack of pecuniary territorial jurisdiction. Moving on to district or subordinate courts. The District Court of India are presided over by a judge. They administer justice in India at the district level. These courts are under administrative and judicial control of the High Court of the state to which the district concerned belongs. On criminal side, the lowest court is that of the judicial magistrate. Now, here is a flowchart describing the various functions of the courts of India. At the lowest level are the subordinate courts. Consider cases of civil and criminal nature. At the next level are the district courts, deals with cases arising in the district, consider appeals on decisions given by the lower courts, decides cases involving serious criminal offences. At the next upper level are the high courts, can hear appeals from the lower courts, can issue writs for restoring fundamental rights, can deal with cases within the jurisdiction of the state, exercises superintendence and control over the courts below it. At the apex level is the Supreme Court of India. Its decisions are binding on all courts, can transfer judges of high courts, can move cases from one court to itself, can transfer cases from one high court to another. Let's gather some information about Lok Adalats. Lok Adalat in India is the People's Court. As the name suggests, Lok stands for people and Adalat stands for court. Lok Adalat is a system of alternate dispute resolution developed in India. This system is an improvement and is based on the principles of Mahatma Gandhi. Now, let us study about fast tracks. Fast track courts are created primarily to deal with the judicial backlog. At the end of March 2019, There were 581 FTCs operationally in the country, with approximately 5.9 lakh pending cases. Under this scheme, the government sanctioned a sum of rupees 502.90 crores to set up 1,734 FTCs in the country. As per the Ministry of Law and Justice, by the end of March 2011, these courts had resolved 32.34 lakh cases. However, since their inception, the number of functioning courts has marginally reduced every year. Now let us study about tribunal. In general, a tribunal is a person or an institution with an authority to act judicially, even if it is not referred to as a tribunal in its title. There are lower courts, civil, criminal, and tribunal, which function under the High Court. For instance, a lawyer appearing before court, even if there is only one sitting judge, he could also call the judge as their tribunal. Let us discuss about the role of the courts. Dispute resolution. The judiciary also plays an important role in resolving the dispute between citizen and the government, between two state governments, and between the center and the state. Judicial review. The judiciary has the power to strike a law passed by the parliament if it believes that these are a violation to the basic structure of the constitution, upholding laws and fundamental rights. If someone believes that his or her right have been violated, he she can approach to the courts to protect his or her fundamental rights. Now let us examine how the judges are appointed. The Constitution of India lays down the rules for the appointment of judges of the Supreme Court, High Court, and the District Court. The judges of the Supreme Court are appointed by the President in consultation with the Chief Justice. Their appointment is held under a collegium system, which is a group of the Chief Justice and the four senior judges of the court. Similarly, for high courts, the President, in consultation with the Chief Justice, Governor of the state, and the Chief Justice of the concerned High Court, appoints the judge. The eligibility for the judge demands a person to be a citizen of India. He must have served an advocate for at least 5 years or as a judge of any high court for at least 10 years to become a Supreme Court judge. For a high court judge, it is necessary that the person must have been an advocate in any high court for a minimum period of 10 years. Accessibility of the courts. In principle, all citizens of India can access the courts in the country. This implies that every citizen has a right to justice through the courts. While the courts are available for all, in reality, access to courts has always been difficult for a majority of people. Legal procedures involve a lot of money and paperwork as well as take up a lot of time. To overcome these factors, the government launched a project known as e-courts. The e-court project was established in the year 2005. According to this project, all the courts in the country got computerized. In 2011, all the district courts were computerized and the entry of backlog cases had started. They initiated the service in the Supreme Court in June 2011. The case list and the judgment of most district courts were available online and used to connect all high courts and Supreme Court judgments and cause list. These websites are updated daily by a technical team. Coming to the end, I would like to thank our principal sir to give this golden opportunity to do this wonderful project on the topic the judicial system of India. I would also like to thank my teacher for making me understand the topic. I gained a lot of knowledge doing this project.